Morning, everybody. Thank you for joining us for our first installment of I Tuesday Claims Edition. Today, we're very grateful to have Mr. Warren Hiepner of Clyde & Co. join us. Warren's going to take us through the intricacies of product liability. Warren is an absolute gem to the insurance industry, advising insurers on various aspects of specialty lines. He has represented insurers and looked after the interests of our insured in some of the most high-profile cases to hit our headlines. Thank you so much, Warren, for making time for us today. And a little later on, we're going to hear from our very own Stacey Lepet. Stacey is a claim specialist at I2 with a keen interest and vast knowledge in public liability claims. Thank you, Stacey. We also have our very own Tamaris Fernandez, who has been dealing with our products liability portfolio successfully for the last 6 years. Thank you, Tammy. So before I hand over to Warren, just to get our creative liability juices flowing and our cogs and gears in motion, we're going to put up a bit of a poll to see what everybody thinks of this scenario. Toes? Here we go.
Do you want to just explain us, take us through?
The scenario is if a petrol attendant put diesel instead of petrol into a car, resulting to damage, is that a products liability claim or a public liability claim? So very interested to hear what everybody has to say.
It's quite a quick poll.
Yeah, it's moving.
That's true.
We've got 61% of the participants who've responded so far, 64%. Some probably need a little bit of time to think about it.
It's an easy one. Well, yeah, Warren and I have a different view on it already. So
yeah, we won't say where we fall.
I see, Deborah, you've got your hand up. Do you want to quickly ask a question? Okay, maybe it was a mistake. Okay, Comedy, do you want me to publish the results? We've got 73% who have participated in the poll.
Yes, please, Tove.
Okay, cool. Steve, I see you've also got your hand up. Don't know if you want to contribute. Maybe not. Okay. Going to share the results. And our expert claim team is going to tell us what is the right answer.
Well, that's for public liability edition 2.
Yes. That's a good idea there.
Okay, well, without any further ado, over to Mr. Warren.
Thank you, Comedy, and welcome to all of you. Can I ask you, Comedy, if you could just start the slide presentation? Comedy is going to be my able assistant changing the slides. I don't have the technical abilities. And perhaps we can just go to the first slide.
Okay, can everybody see?
Yes, we can.
Okay.
Comedy. Margie is saying that sound is very soft. Please just check that your sound is on full.
Okay, I will do so.
Cool.
Okay, so let's kick off then. And what I thought I would start with is just give you a quick summary of what today's plan of action is. The first part is dedicated to be looking at the overview of product liability in South African law. That I will attend to, and I'll also then be looking at the typical product wordings and the structure of the product wordings. In this particular instance, it's one of the I2 products. The claim scenarios, I'm going to be ably assisted with by Stacey. We'll deal with some of the claim scenarios and how we see the claims being dealt with on various factual scenarios. We'll then look at some of the significant global and local product liability cases that have hit the headlines and that I'm sure many of you have heard of at some point in time. Tamarisk will help me out there. And then I'll come back in at the end with some closing remarks on risk management strategies from my perspective as an attorney dealing with some of the claims that we encounter. Okay, Comedy, if you could change the next slide, please. Okay, so let's talk quickly about product liability in South African law. And what is essential to remember is that what we're in essence talking about is the legal liability of an insured to a third party for injury or damage caused by a defective product introduced into the distribution chain by the insured, either as a manufacturer, importer, retailer, distributor, whatever it might be. And there are basically three grounds upon which that liability can be founded, and that is contract, delict, and the Consumer Protection Act. And perhaps let's just start with contract. Now, you would understand, obviously, that the liability there is a question of what the contractual terms say, and it's a liability that is between the two contracting parties, and it's ordinarily limited to the terms of the contract. The advantage for the insured in relation to contractual liability is that there is normally a potential to rely on exclusionary clauses or indemnity clauses or limitations of liability, which in the ordinary course form part of the contractual terms that are negotiated between the parties. Obviously, it's dependent on the negotiating strength or the negotiating positions of the parties. But it is fairly limited as far as the exposure is concerned in the contractual sphere. Delict is the second ground, and that tends to be a little wider. And the way the delict arose, the issue arose, is that initially our law recognized only delictual duties of care in the same context as the contract. In other words, the contracting parties owed each other a delictual duty of care. Many of you will have heard of the snail in the ginger beer case in the UK, and that broke the UK law free from that restriction. And we have followed suit, I think, in about 1970, where we also have a situation now where delictual liability is far wider than the contractual parties entering into a contract. Obviously, the downside of that is that liability there is to anyone. The upside of that is that there is this requirement that any claimant who wants to pursue an action against an insured will have to establish that the insured was negligent. And that issue of negligence in product liability has long been the subject matter of concern amongst our courts and amongst our judges. And one of the reasons for that being so is that it was seen as very, very difficult for a third-party claimant to know exactly what the manufacturing process or distribution process is of a particular insured. And therefore, it was very difficult for a man in the street to be able to establish that that particular entity or the insured was negligent. And it's for that reason it came before our courts at a time where there was a question raised subsequent to our Constitution, where the question was raised, well, isn't it time that we started looking at allowing a strict liability situation to alleviate that heavy burden on the third-party claimants? And it's as a result of that concern and that perceived burden that we now have the Consumer Protection Act, which came out in 2008, but I think it only became effective in 2011. It wasn't an easy birth, that act. And what it does is, the particular section that we're concerned with here in relation to product liability is the section relating to liability for unsafe, defective, or hazardous products. And that's section 61 of the Act. And what that section does is it creates what is commonly called strict liability. And it's in the sense that there is no necessity to prove negligence on the part of the insured. A third-party claimant will succeed without having to prove negligence. It doesn't mean that there aren't any defenses. It's not strict liability in that you prove the loss and the causation and your home. There are stated defenses provided for in the Act. There's a number of them. I think there's 4 or 5 of them. So it's not the end of the world, and one doesn't throw one's hands up and pay every claim. One still has to deal with the claim under the Consumer Protection Act and determine whether, in fact, any of the defenses are applicable or not. A couple of things to remember in relation to the Consumer Protection Act. The first is that the Section 61 provisions apply to any product that is supplied or sold within the Republic. Although the Act itself limits consumers to natural persons and commercial entities or judicial entities having a net worth or income, net annual income, I think the current threshold is 2 million rand. But Section 61 is not subject to that restriction, and Section 61 applies to any products that are supplied in South Africa. Some good news in relation to Section 61. One is that there has only really been one case, which is kind of surprising. We anticipated when the Consumer Protection Act came out that there was going to be this deluge of claims. When we do see Consumer Protection Act claims, we see them in the context of alternative claims to normal contractual claims or delictual claims. So that's the first thing. And the second thing is that that one case that has dealt with the issue has concluded that the Consumer Protection Act is only applicable, and certainly Section 61 is only applicable in relation to parties or individuals who are using the product as a consumer. And the case that's involved is the Holstead case. And what had happened is a cyclist had come into contact with a low-hanging electrical power line and suffered severe injuries and proceeded to institute an action under Section 61 against Eskom. And the court there said that the cyclist wasn't a consumer relative to the supply of electricity at the time. He just happened to encounter it. So he wasn't using the electricity. It hadn't been supplied to him. And for that reason, the court said Section 61 was not applicable. So there is some light at the end of the tunnel. Comedy, if you could change to the next. Okay, so that's the liability. Well, how does the insurance industry respond? Well, it responds with product liability indemnity insurance. And what I have up on the screen is the IT general liability insurance policy provisions. I've underlined in the indemnity agreement just what you would know to be the normal essentials of the claim may be first made during the period of insurance, and for it to arise from the performance of the business and within the geographical limits. And then Section 2 is the product liability and defective workmanship section itself, the indemnity clause that we are concerned with. And of course, it deals with legal liability for damages and claimant's costs and expenses for and arising from. And of course, the important wording is at the bottom of that slide: bodily injury or property damage suffered by a third party caused by the nature or condition of your product. Of course, those items that are capitalized and in bold are then defined under the policy. Carmen, if we can go to the next slide. In that same section, there are then a number of specific exclusions. I've listed 4. I think there are only those 4 as far as I recall. Of course, export product to USA, Canada, that's of course a fear on the part of the insurers relating to the unacceptable risks of litigation and the awards that are made in the USA and Canada. Products used or incorporated in aircraft or aerial devices. I assume the aerial devices has been added as an add-on to deal with things like drones. And then there is the failure of the product to fulfill its purpose, the inefficacy exclusion, and we'll talk a little bit about that when we talk about the inefficacy extension. And then there is the cost of repair, replacing, or reinstating the product. That's the product exclusion. And of course, the other side of that is then product guarantee cover, which would provide you for the cover, with the cover for the cost of repairing and replacing the product. There is an extension, an automatic extension in relation to vendors with listed exclusions, and that's effectively extending the cover to those who distribute or sell the insured's products. And then, of course, we have the product inefficacy extension, and that's not an automatic extension, that's an only if stated extension, and that's the one that we will deal with a little later, and it deals with the issue of where you don't have property damage, but you do have a reduction in use or value of a third-party product. Okay, so that's the liability and the product liability wording response. Let's consider where the shoe pinches, so to speak, by looking at a couple of scenarios, and I'm going to call upon the able assistance of Stacey here. And perhaps I'll run through a couple of issues which I've seen where the problems arise. And the first one relates to what is a product. And here I'm particularly concerned with the distinction to be drawn between a product and a service. And product, as I stated, there is a defined term within the policy itself. And the scenario I've posited there is the insured is contracted to supply a concrete base for a crane. The concrete base was constructed on site by the insured. The concrete base fails under the load of the crane, and the crane collapses, and the owner of the crane then seeks to hold the insured liable. And the question is, well, on the facts as they are there, is there to be cover? And in particular, does the concrete base constitute a product? And surprisingly, this matter actually came before a UK court. Facts identical to what I've recited there. And the court looked at this question of whether the concrete base constitutes a product and concluded that the contract that was concluded between the party who had contracted the insured to construct the base was a contract for the supply of products and for services, for work and materials. It wasn't for a product. The court also considered the fact that this concrete base is not something that was a stock item of the insured, not like a boiler or the like, and couldn't be ordered and delivered to site, and it was constructed on site. And throughout the judgment, you'll see they reference it as a lump of concrete, and the end result was that the court considered or concluded that this was not a product, that it was in fact the provision of a service, and for that reason there was no cover in respect of the claim. They did raise the issue. You'll see in the definition of product there is reference to erected, and it does seem that was argued in the court that, well, was the concrete base not something that was erected, and the court seemed to take the view that that which is erected consists of components that are put together, and rejected that argument and came to the conclusion that there was no product in those facts. Stacey, I don't know if you have any comments or issues you want to raise in that regard.
Yes, Warren. What if the definition of product included a reference to a product constructed by the insured?
So what we're saying is in amongst this definition of product, we then have the word constructed. And the funny thing is, if you go and look at the case, it actually did have the word constructed in that definition. And I myself would have thought that that ought to qualify the concrete base as a product, something that was constructed. But it wasn't argued in the case, and one doesn't know if the court actually considered it or not. But I think it would have made a difference. Certainly, I think it would make a difference if it was something that came before our courts in South Africa. Okay. Anything else that you want to raise?
Yes. Why is there a need for the product to have left the insured's custody or control?
Okay, so in the definition of product, you'll see it runs on and talks about, well, actually at the beginning, it talks about the product having left the care, custody, and control of the insured. And as I understand it, that draws the distinction between where product liability starts. And that product liability only really starts once the product has left the care, custody of the insured and has entered, so to speak, the distribution channel. There, of course, may be liability before it leaves, But I don't think that liability ordinarily will be considered to be product liability. Normally, I think it would be in the realm of a general liability or public liability, depending on the nature of the claim. But I don't think it's there to draw that line, so to speak, between when does product liability, as we know it, the liability for defective products put into the distribution chain, it's to draw that line. Anything else on that?
No.
Okay, Carmody, if we can go to the next slide. Okay, let's talk about property damage quickly. Another issue that is often debated in these types of claims, and bearing in mind that the property damage is a defined term in the policy, and it requires essentially physical damage to or loss of destruction of property. And property itself is defined as referencing tangible property. So physical damage in the ordinary course can be considered to be the causing of harm which is perceptible to the senses. It's apparent, it's physical. And the scenario that I've posited there is an insured sells a product for the control of fungus on fruit. And this is a case I actually handled at a point in time. The farmer uses the product and it causes discoloration of the skin of the fruit, which cannot be exported because of this discoloration. They're quite finicky about what they will accept in other countries, surprisingly. And the farmer then seeks to hold the insured liable. And the question is, well, is there likely to be cover in that situation? And my sense is that yes, the discoloration, as I see it, qualifies as physical damage. It's a type of harm which is perceptible, and that has caused a loss in relation to the export capability of the fruit concerned. And as a result, I think that the liability that the insured faces to that farmer is likely to qualify for a indemnity on the basis of there is property damage. I want to change the facts a little bit, and maybe Carmen, if you move to the next slide. And let's change the facts a little bit. Let's consider that the discoloration can be easily removed. In other words, just be washed off, and without damaging the actual fruit. And the question then is, well, is that to be considered to be property damage or not? And there's a debate about that. You know, there are I'm not sure if you involve yourself in some of the COVID-19 cases, but sometimes the COVID-19 cases, there's this debate about whether there's damage or not. And in the UK, they've considered issues of damage in relation to dust or radioactivity that is present and whether that constitutes damage. And the cases seem to be a little bit split on that. They require some physical change to the third-party product for there to be property damage. There are other cases that seem to think, well, as long as it's difficult to remove that which is now evident on the product, that would qualify as damage. So it's a little uncertain at this point in time. Maybe we might get some clarity when some of the COVID-19 cases go through the issue of determining what constitutes damage. Anything there, Stacey, you want to raise?
Yes. What if this fruit can be sold locally with the discoloration?
Okay, so I don't think, well, let me precursor that. The first thing, will depend on what you can sell it for locally. But my sense is that provided the local sale is less than the export sale, which it probably is, otherwise they would just sell the product or the fruit locally. I don't think it matters that it can be sold locally. I think all that matters, all that affects is likely affects the extent of the liability. In other words, there will be a mitigating effect on the potential liability of the insured in that the local sales will reduce the extent of the liability. So I don't think it really changes the scenario. Anything else?
Would it have made a difference if the only reason for the discoloration is the incorrect application method set out in the label or instructions?
I don't think so. And I say that because if you look at the definition of product it is fairly wide, and it ordinarily includes instructions. Some of them go further, I think, and I think the I2 goes further. It also includes advice that is given in relation to the product. So I don't think it makes any difference at all. Anything else?
No.
Okay, Carmen, if we go to the next slide. Let's talk again about, still talking about this property damage. Another scenario 4, an insured sells seed A for planting and growing of crop A. Farmer purchases seed and the seed does not grow at all. So the question is, well, is that property damage? I don't think it is, because I don't think that there's any property damage that has been caused. It's the product itself as well, which is another factor which makes it a difficult one to fit into the policy. So I don't think in that scenario you're likely to have the entitlement to indemnity on the wording as we currently have. Any questions you want to ask on that one, Stacey?
Yes, Warren. What if the seed is contaminated and grows into crop B instead of crop A?
Okay, so we sell seed A and it ends up growing crop B, and the question is, well, is growing crop B then physical damage? My personal sense is I don't think it is physical damage, but I can tell you that there is an Australian case dealing with this kind of situation in relation to some grass seed that was sold, and that grass seed was sold as grass A and it ended up being grass B, and the court approached it on the basis that the claimant in that case wasn't seeking to have or claiming the damages for having A instead of B as the grass, but in fact was claiming for the damage to the land, and that having to remove now this weed grass that had been grown as a result of the contamination of the seed. So I think it's not, but there is arguments in Australia, and you'll have to litigate in Australia if you want to succeed. There's arguments in Australia that there is physical damage in those circumstances.
Okay.
Anything else?
What if the insurer didn't sell the seed, but sold an agrochemical used on the seed which was supposed to promote growth, but which prevented or stunted the growth instead?
Yeah, I think what you do there is by bringing in the agrochemical, you now create the opportunity for the insured to contend that, look, the damage is outside of the product that he provided. That's kind of the stereotypical type of product liability claim where he sells a product and the product causes damage, physical damage. So I think there's likely to be cover in that situation.
What if the agrochemical didn't have a good or bad effect?
A little bit more complicated. The problem there is that if the agrochemical does nothing, the question is, well, where does the liability sit? And I think what you start doing then is you start moving towards the realm of the inefficacy cover, and we'll deal with that when we come to the inefficacy extension, and we can deal with a similar scenario under that one. Happy?
Happy.
More or less. Okay. Okay, if we can go into, let's move on to the product inefficacy as we've spoken about it now. And this is probably the most prevalent extension that we see debates about. And of course, two important aspects here. The first one is that it extends the cover to beyond physical damage. And what it effectively says is the insurers will not raise the absence of physical damage provided two requirements are met. The first one is that the third-party product has been rendered of less value or full commercial benefit, less than full commercial benefit. But importantly as well is it must be something other than the product that has been rendered of less value or less benefit. Carmen, if you could move to the next slide, please. Okay, so let's look at a scenario, and we'll just revisit the scenario that we already visited with the scenario 4. Insured sells seed A for planting and growing of crop A. farmer purchases seed and the seed does not grow at all. I don't think on those facts that it helps the farmer. There is, yes, there's no physical damage, but when the seed doesn't grow at all, there is nothing but the seed. So my sense is that there's nothing other than the product which has been supplied by the insured. And as I said, the requirement of something other than the insured property being rendered of less value is absent in those circumstances. So I don't think that the insured is going to get home on that factual scenario. Any scenarios you want to add to that, Stacey?
No. I do have a question.
Oh, okay.
What if the seed grows into crop A, but the growth is stunted?
Okay, so there is growth, but it grows into a crop. And I guess the debate there is going to be whether the crop is something different from the seed, because remember the inefficacy, you're going to have the effect, the reduction in value or benefit being on something other than the insured product. My own view on that is that I think the crop is something different to the seed. And I say that because it seems to me that one takes a seed and you have various inputs that you give to it, water, light, loving care, you talk to it, those sorts of things, and suddenly it grows into something. And my sense is that which it grows into is something different. And I think there is an argument, a good argument to be made that there would then be an efficacy cover in those circumstances. Of course, I could be wrong. Anything else?
How would you know if an inefficacy extension is needed on a policy?
Yeah, and I guess that's probably something that your brokers are far better positioned than me to tell. But from my sense, you would need that kind of extension if you are selling a product or marketing or manufacturing a product, or your insured is doing so, should I say, which is used in conjunction with other products, either as a component or added to or put on or whatever it might be. And where that failure of your product has the ability to inhibit the overall product or someone else's product from reaching its full potential. And yet I'm particularly thinking of things like reaching its full size, shape, taste, speed, whatever those attributes are, but it's something that prevents it from reaching its full potential without actually damaging it. And it seems to me those will be the situations where you're going to need this efficacy extension if you want to get back into the cover. One important thing to note, though, is in the IT policy, if you look at the inefficacy exclusion, it's not a total exclusion. It says it excludes the failure of the product to operate as intended or to fulfill its intended purpose, but then it carves back into the cover a carve out for the consequential physical damages. So there is light there as well, which you can potentially pursue if you're an insured and looking for the cover under the policy. Okay, that's inefficacy. Thank you, Stacey. Anything else that you wanted to raise?
No, thank you, Warren.
Okay, let's go on to the cases, and here I'm going to hand over to Tamarisk, who will take us through, and I'll provide whatever comment I can as appropriate. Thanks, Tamarisk.
Thanks, Warren. Good morning, everybody. So we're going to start looking at some well-known overseas cases. I'm going to start with the Liebig versus Mcdonald's restaurant. This was a highly publicized 1994 products liability lawsuit in the United States. I'm going to give you some background on this case for those who don't know. So Liebig she was at the age of 79. She ordered a cup of coffee from the drive-through window of McDonald's. She was in the passenger side in a vehicle which did not have cup holders at the time. The vehicle was stationary when she placed the cup between her legs and pulled the lid off to add sugar. In this process, she spilled the entire cup over on her lap, which resulted in third-degree burns following skin grafting and a lengthy time of medical treatment. Her legal representative formulated the claim against McDonald's on the basis that at 100 to 190 degrees, the coffee was deemed defective and more likely to cause serious injuries than coffee served at any other establishment. McDonald's refused several opportunities to settle for less. I would say they were the author of their own misfortune, because the jury reached its verdict applying the principle of comparative negligence. The jury found that McDonald's was 80% responsible for the incident and Liebig was 20% at fault. They substantiated their verdict saying that although there was a warning on the coffee cup, the warning was neither large enough nor sufficient. So $2.8 million was awarded to the plaintiff in this case. Warren, is there anything that you would like to add?
Yeah, I just like to say something about that. People often listen to someone saying something about the McDonald's coffee case and they say, well, that's ridiculous. How can a woman claim for hot coffee? Everybody knows coffee is hot. Two things to remember. The number one is McDonald's took a conscious decision to keep their coffee at, like, I think it's 20 degrees higher than anybody else. And it was a marketing ploy because they understood that drinkers of coffee like hot coffee. So, and they had about 700 or 800 claims of people being burnt before this, and they ignored those claims. That's the first point. The second point was McDonald's also, I think she claimed, initially $20,000. They offered her $800 and they refused to budge. They would not give her a cent more. And they ended up then having to pay her, I don't know what the eventual settlement amount was, but it just shows you must, if you're going to have product liability claim, you need to deal with it and resolve it and not let it get out of hand as the McDonald's case got. Anyway.
Yeah, I just want to add on that one as well. Up until today, they still haven't reduced the service temperature.
Yeah.
And they are currently serving coffee at about 176 to 194. So the only precautionary measures that they did take was improving the packaging and the warning signs.
Yeah, naughty buggers. Okay.
Okay, so let's move on. Our next case is also a very well-known product, our Johnson & Johnson baby powder. So as you all know, Johnson & Johnson introduced baby powder made of crushed talc. However, talc can sometimes be contaminated with asbestos, which is the mineral that can cause cancer if the fibers enter the body. The FDA done testing on 10 cosmetic products, and Johnson & Johnson was found to be highly contaminated. Johnson & Johnson has lost 38,000 multi-million-dollar lawsuits related to ovarian cancer and mesothelioma caused by the baby powder. Those who don't know what mesothelioma is also a type of cancer that does attack the lungs and the organs. So what Johnson & Johnson done after that in October 2021, they moved the potential liabilities for the talc products into a separate company, like a subsidiary, which then entered bankruptcy in a highly controversial move in order to limit their financial exposure. Warren, you want to add anything to this?
I just marvel at that kind of conduct. I mean, your name is front and center, Johnson & Johnson, and you're prepared to try it, and I think they're going to get away with it now. And one other thing, just to note in that case, you'll see every American has used talc powder sometimes is one of the bullet points there. They're lucky at this stage that it's only been linked to ovarian cancer, because that limited the class. That class could be every single US citizen if they are able to establish something other than ovarian cancer, some other diseases. And that case could get out of hand very, very quickly. And that might be why they're prepared to take the reputational risk of doing what they're doing. But not great conduct on their part, I've got to say. Unless I'm acting for them, then they're doing the right thing. Okay.
Great. I was wondering, Warren, in terms of, did they remove the product completely, or did they just replace the talc with a different?
I think they've replaced it, because I still see the product. Although South Africa is not, and you will come to it, South Africa is not a good judge or not a good measure to determine whether something's defective or not, I've got to tell you. And we'll see that in this Monsanto case.
Okay, so going on to our following one is the Monsanto Roundup. Monsanto produces the product Roundup. It's a glyphosate, the most widely used herbicide. So as of October 30th, 2019, there were over 40,000 plaintiffs involved with a $10.9 billion lawsuit saying that glyphosate-based herbicide caused their cancer. Although Monsanto argued that the plaintiff's claims were based on junk science and sought a summary judgment dismissing the cases was eventually consolidated on the basis that the jury found that Monsanto had failed to adequately warn consumers of cancer risks posed to the herbicide, but the product's still on the market. Warren?
Yeah, no, that product is still there. And I've actually got it looked in, and I think it's still got that glyphosate in it. And I've actually used the product, believe it or not. And I remember reading an article at some point in time that said you don't have to use it over a long period of time. You can use it, occasionally. It comes in a little spray water bottle that you can use on your driveway, and it works impeccably well. I must say, it's the most effective herbicide I've ever seen. But of course, what you don't realize is it may be causing you substantial physical harm in the process.
Yeah, I also read the article where Monsanto said that the amount used in gardening can never be enough to actually cause the cancer. So that was also one of their arguments.
That's that old adage, whoever pays the piper, calls the tune. And you're going to get whoever pays the experts normally gets the kind of gets the views that they want. So you can have experts on both sides. You'll have the experts who'll say no, absolutely not, and you'll have the experts who say. So you just got to decide where you want to, what risk you're prepared to accept. Okay, so we move on to the next one.
Yes, we're going to move on to a more local case here in South Africa. Everybody knows this one. It's our Tiger Brands Listeria. So this is the Listeriosis Outbreak, which began at the start of 2017 and was declared over in September 2018 with 1,065 confirmed cases and 218 deaths. The World Health Organization experts said that this is the world's largest documented listeriosis outbreak ever. It was traced in March 2018 to a ready-to-eat processed meat product called bologna, which you all know, made by Enterprise Foods, which is owned by Tiger Brands. The class action is on behalf of those who were sickened by the contaminated bologna and families who have lost relatives. Warren, please.
Yeah, that case hits a little close to heart because I'm actually involved to a degree in that case. So the importance of the case, I think, is first of all, it's the first large-scale product liability class action that has been launched in South Africa. It was done on an opt-in, an opt-out, opt-in basis. There's two stages to the litigation. So the litigation is split between determining the merits and then determining the damages. And in the merits, it was on an opt-out basis. So anybody who falls within the definition of the class is in the class unless they asked to be opted out. But once the liability is established, if it is established in the damages section, you will understand you need to then bring the individuals to come and claim what it is that they're claiming. So that's on an opt-in basis, and that's still going through. But what is quite important to know is there's foreign interest and involvement from foreign lawyers in the case. There's also involvement of litigation funding models, which is becoming quite big business. I think in Australia, it's massive at the moment. And the other important aspect of that case is that it does deal with the question of constitutional damages, which has been raised. And the constitutional damages in the ordinary course are a type of punitive damages, unlike the states, so it's a little much more tempered. But what it is it's the state expressing its displeasure with egregious conduct. And an example of that you would have seen in the Life Esidimeni, where awards were made for payments to individuals because of the way they had been treated, or their loved ones had been treated. So something to bear in mind is to just look out on this constitutional damage issue, because it does have some far-reaching implications. That's my comment on. I think that's all I can say on Listeria. Okay, shall we? Thanks, Tamarisk. Anything you want to add?
No, thank you very much.
Okay, thank you very much. Okay, the last little bit for me to jump into is, as I said, is my perception on the risk management issues. And as the way I see it, there's only three things really that an insured can do. They can either avoid the claims or stop the claims, number one. Number two, they can deal with the claims in a proper and efficient manner. and number three, they can try and anticipate the trends or where the claims are likely to come from. And I kind of set those out in the two slides that we're going to see here. The first one is the preventative or reduction of the risk of claims. And of course, there's the upstream efforts that one can make to manage your suppliers and importation of goods. The consequence of globalization is there's been a lot of concentration of suppliers or supply chains, and normally around the cheapest supply chain. A lot of that is coming through from China, and you would know probably that China has a bit of an inconsistent pattern of quality standard and inconsistent approach to quality standards. So there are some challenges there. Downstream is fairly self-explanatory, just takes a bit of thought as to identify what those risks are and see if you can. Of course, economics will dictate whether the safety measures are capable of being built into the design. Quality control measures or quality control systems, a lot of that is taking care of itself. Again, with globalization, there are a lot of requirements of meeting international standards so that there is free trade amongst different countries and amongst different unions and states. So an example is the FSSC 2200 in relation to food safety and the upgrade of food safety certification to that level. Again, it's driven a lot by the globalization in the market. Early warning is just to obviously nip it in the bud, and there's no use having, one thing one learns is that it's no use having the early warning system if you don't have the proper channels of communication to reap that information and be able to deal with it. The second grouping is responding to the claims. The enabling and review of customer feedback is quite important. And what that does is it gives you quite an early insight into claims and where they may be coming from. Again, you have to have proper channels of communication to deal with that. Monitoring identification of trends and hotspots. It's again puts you ahead of the game, and of course having a contingent plan in place before the event happens. The reality is, if the claims are happening and you don't have the plan of action, you are going to be caught short, because demands are going to be made upon you or on your insureds far beyond putting together plans as to how to deal with these issues. In particular, issues of public relations and reputational damage need to be dealt with. So it's better to have the plan in place if you can. Of course, the manner in which you respond to the claims, as shown by the Mcdonald's case, can sometimes be important. And as I said, in relation to constitutional damages, the way the claims are dealt with may also be a factor that is taken into account in deciding whether or not, and if so, how much constitutional damages may be awarded. Carmody, if you could go to the next slide, the last slide. Okay, the third issue I thought might be of assistance is to consider impacting trends. And the first one I've identified there is that we are a now nation, or a now generation, should I say. Everybody wants things now. Consumers demand products that are ready to eat and ready to use. And what that obviously does is it shifts the entire responsibility for the adequacy of those products that are ready to eat and ready to use to the distribution line, and sometimes to the last person in that distribution line. There's no more opportunity for checks and balances. It's for up to the supplier to make sure that the product is properly cooked or properly put together. So it does tend to heighten the burden or increase the burden carried by the distributors, those in the distribution line. Regulatory focus. Me personally, I think we are regulated up the wazoo. I cannot understand how much regulation and why we need all this regulation, but it is what it is. And it's across all boards and across all industries. What it does is, first of all, it sets the bar as far as the expected conduct is concerned. So if your insured is falling short of that bar, it's going to be glaringly obvious But also what happens is you find regulators, when they first take on their positions, there's a tendency of flexing of muscles. So there are normally a few cases, token cases, where somebody is going to be taken to task just to show that the regulator is there and he has the ability to do what he says he's going to do. In South Africa at the moment, there is quite a big focus on food safety. There was an article recently where there was a call, and I think the president may have also mentioned it in one of his speeches, that there's a call for a separate food safety regulator, because at the moment food safety in South Africa is very fragmented. Part of it's under the Department of Trade, part of it's under the Department of Agriculture, Fisheries and Forestry, and part of it is under the Department of Health. And they want to try and put that all together. So you'll have to watch the spot of regulation and regulatory introductions to see where it's likely to fall. Product recalls. Now, recalls normally give you an indication of where the claims are going to come about and where they're going to arise, potentially. There is a website by the Organization of Economic Cooperation and Development where they keep track of, and if you need that website, you can just contact IT and we'll send it to you. But what they do is they keep track of global trends in relation to recalls. It's a global portal. Doesn't include food though. Surprisingly, if you look at that portal, you'll see the highest incidence of global recalls at the moment is in relation to toys and games, and I think that's related to the children and children being at risk of doing things with toys that shouldn't be done. And then I think automotive and somewhat not surprisingly, China, I think, is listed as the country of origin of most of the majority of the recall claims. One surprising thing, if you go to that portal, you'll see there's a very low reaction rate. So there's a lot of recall of products, but not a lot of people actually do anything when they realize they've got a product that's been recalled. I think it's like a 3% response or reaction, which is kind of strange if you think about it. And of course, the National Consumer Commission also has product alerts and recalls that they embark upon. The last point I wanted to make there, and that's just in relation to the legal sphere in particular. And you would know that the MVA avenue for a lot of personal injury lawyers was stifled as a result of the changes that were made to the MVA legislation. And of course, a lot of them then filtered across into medical malpractice. And the talk in the town is that that's going to also be choked off at some point in time, because the state just can't afford to pay the kinds of claims that are being made. And the question is, well, where are these lawyers going to find their next fertile ground for litigation? And it may well be in the product liability sphere, helped by the fact that we have, in South Africa at least, we have a fairly concise and supportive contingency fee agreement provisions in the Act, and they are often used. We also now have class actions which are firmly established as something that can be pursued. And of course, now it's driven to an extent by foreign interest, where we're having foreign lawyers and foreign funding coming in to try and drive the litigation process. So just something to bear in mind going forward. And that's it as far as risk management is concerned. Next slide is the question slide. So I guess does anybody have any questions they want to ask myself, Stacey, Tamaris, Kamini?
There are a few questions in the chat, if I can read them to you.
Okay. Right, answer these.
The first one is from Ernst. It's a scenario. So he says, the company produces root steel pipes for water schemes, product under stringent quality control, but is powder coated by a subcontractor to a certain thickness. Civil construction company installs 5 kilometers of faulty product, the defect still not known at the time. Later, the stock in their yard gets inspected with a micrometer, and the thickness of the coating is found to be below the spec. Civil contractor sues the manufacturer for cost of upliftment and reinstallation. Product is fixed and transported at manufacturer's cost. Let me just see here. Insurers decline the claim of the manufacturer for damages claimed due to the product not failing? Comment, please.
Yeah, I'm hoping I understand that factual matrix, but it sounds to me like there's a question of a coating that is inadequate on a product. But it doesn't seem to me like there has been a causing of any injury or damage as a result of the product. Whether one could have an inefficacy claim in that situation, I guess the debate will be whether there is something different than the product of the insured having been rendered of less value or benefit. And it might well be that the pipe does qualify as such in relation to the coating, assuming that the coating is the issue. So it's quite a complex factual matrix, but I don't think it's clear cut either way.
Yeah. Okay, then Jose wants to know about pure economic loss following property damage, the cover for pure economic loss. I think this is in relation to the seeds scenario that you and Stacey spoke to
Yes.
earlier.
Okay. So I think one must be careful about distinguishing pure economic loss from non-physical damage. The reality is, in law, you are liable for the losses that are consequent upon your breach of either the contract or the breach of your duty of care under delict, or the breach of the section of the Consumer Protection Act. And if that pure economic loss forms part of that loss that you are ordinarily liable for, then you're liable for it. Debates, however, come about when you only suffer pure economic loss. And the difficulty in South African law is that certainly in the context of delict, pure economic loss is seen as an extension of delictual liability. So the law starts with the default position of there's no cover, and there need to be policy considerations extending the delictual cover to the pure economic loss. Under the Consumer Protection Act, there is a provision for economic loss, but that economic loss is stated to be as a consequence of either the illness, injury to the person, or damage to property. So it's quite restricted in the Consumer Protection Act, although there's a debate about the use of the word including in the section dealing with, I think it's section 61.5 of the Act. But pure economic loss, if it's part of the liability, then it follows the liability, and you ought to be able to recover it.
Thank you, Warren. Learning so much today. Okay, so Megan says anyone who burns your coffee should be sued. True, Megan. Santo Rondo case is shocking. Okay, Nadia asks, we have seen an increase in litigation over the years. What kind of compensation or damages can be awarded in products liability cases? And have you seen a shift in the approach of courts in these type of matters? So maybe the what is it? Constitutional damages coming.
Yeah, so that's the first thing that I mentioned that we have seen. We've seen this rise of this issue of constitutional damages, and of course it's the claimants, and while they obviously want to get as much money as they can as compensation. And there are, one has to admit, there are certain aspects of damages that are not adequately catered for in our law as it currently stands. And that's where the constitutional damages come in. One of those is in response to egregious conduct. We have not seen, and as I say, we haven't seen a hell of a lot. I think there's about 18 reported cases on product liability per se. So there's not a hell of a lot of cases. And one of the things that is a saving grace in South Africa is that we are still quite tied to true compensation. So we haven't allowed, other than this constitutional damages issue, the courts haven't allowed damages to get out of control. You still have to prove that which you say is your loss. And if you're able to prove it, good and well, you'll get compensated. But you're not going to be able to look for exemplary or for damages other than that are sufficient to satisfy or to indemnify you in respect of the loss that you've suffered. So I see the trend of the constitutional damages, and I potentially see the trend of more claims, but I don't think the damages themselves are something that we are going to see out of control, unless there's some statutory provision that comes out at some point in time that makes it so.
Thanks, Warren. Tove, I see that we have reached our hour.
Yeah, we have Comedy. I think we can squeeze in 2 more questions if that's okay with you, Warren.
Absolutely. I should have said at the
Okay.
beginning, you should only ask questions that I can answer, not questions I can't answer. Anyway.
And then we'll just post the recording on our YouTube channel for anybody that does miss the last bit.
Okay, thanks, Tove. So Reggie asks, defective workmanship cover provides cover for liability arising out of defective work, but will the cover provide consequential loss following? Will there be cover for consequential loss following the defective workmanship?
I'm going to say I don't know. It depends on what the wording is, and I haven't looked carefully at the defective workmanship extension that is provided, or the cover that is provided under the policy, and whether there is an exclusion. You remember that as well, that although there are specific exclusions in the sections dealing with product liability and defective, they still remain subject to the general exclusions. So I don't know to the extent to which the policy is for it or not is one issue, and whether there's cover for it or not is a different issue. That second issue is going to depend strictly on the wording of the policy and how it is to be interpreted as to whether it's properly excluded or not.
Thanks, Warren. Tove, I think Melita wants to come in here.
I know, Melita.
Hi there, Warren. How are you doing?
Good, yourself.
Yeah, very well. Yeah, just to comment on that defective workmanship issue, there would be cover. I mean, defective workmanship cover is kind of consequential loss in of itself, because it's after the work has been completed and handed over, and it's as a result of the defective work that you would pick up the losses. So we don't cover the part itself or the item worked on, and there's a big debate about what that means.
Yes.
But certainly all the consequential losses that flow from the defective work are included in the cover. I hope that.
Yeah, I guess. No, and I think that's right. I think what you'd have to just be careful is that there are losses that are consequent on the defective work, and there's consequential losses.
Yes.
And you just need to make clear in your mind which are which, because there is a line that gets drawn as to, well, where does the cover end? So you just need to be able to draw that line.
Yes, right. Sure, absolutely. That's a good point, but I think there is cover. As far as I recall, and I'd have to revisit my policy wording.
And it must be so, because
we don't have an exclusion that relates specifically to that.
Yeah, and it must be so, because if you think about it, the defective workmanship, absent product guarantee cover, you're not replacing the defective part. So there must be cover for the consequence of that defect. How far that cover extends, I don't know. And as I say, it depends on the wording, but there must be something other than the defect itself, because that's not covered unless you have the product guarantee cover.
Right. I think if it's caused sort of physical damage, and then there's losses that are sort of premised on that, whether it's a loss of it's downtime in the business or something, that should be covered. Yeah.
Yes. I'm just
Thank you both.
quickly.
Okay, so last question, I think also for you both from Willie. In your view, what should brokers take into account in advising their clients as to what limit for this cover is appropriate?
I am going to bow out of that question because I have no idea.
Okay.
Will Melita have insight on that, Comedy?
I'm not sure. Melita?
Are we asking, sorry, it was a question about what sort of limit you should be looking at.
Yes, so Willie asked what should brokers advise their clients as to what type of limits to take for product liability?
It's such a difficult question to answer. I guess it depends on the nature of the product, the extent to which it's distributed, where it's distributed, the territories. Because depending on where it goes, you could obviously have different claims that arise and more litigious societies that are involved. But it's such a difficult one. I mean, the answer always used to be, well, how much can your client afford? And then you kind of step on a limit and you work backwards. But I think it's really difficult. I think the insured themselves need to try and work out what a disaster scenario would look like, and then try and append some kind of value to that. And then if they can, get a limit involved, but also to factor in that, of course, legal costs are part of that. So it's not just the indemnity you need to pay out, you need to make sure that you've got sufficient limit there and sufficient amounts to be able to pay for excellent attorneys like Warren, who can assist and defend those kind of claims. So,
I was just going to say the legal cost part is a small part of it.
yes, Warren. So yeah, it's such a difficult one, but I think, yeah, together with the insured, try and work out what is going to be sufficient to hopefully get you over the line in terms of defending the claim, and God forbid, but if you do need to pay out, that there is sufficient for that indemnity as well.
Thanks, Bernice. Okay, well, I think.
Thank you, everybody.
Have a good day, everyone.
Thank you, everybody.
Thanks, everyone.
Thank you.